Good afternoon, everyone. Could we all stand for prayer, please? Most heavenly and eternal God, as we come before your presence today, I just want to thank you for this opportunity. Thank you for good weather, and thank you for allowing all of us to reach here accident-free. To those of us who are not here yet, please allow them to be here accident-free as well. For the proceedings today, I ask that everything that is said and done be to the honor and your glory, and also to the benefits of the citizens and residents of the territory of Montserrat. In your name I pray, amen. Please be seated. My name is Dwayne Brissett. I'm the Information Services and Communications Manager at the Eastern Caribbean Supreme Court Headquarters in St. Lucia, and I'll be your moderator for this evening event. Her Excellency Mrs. Sarah Tucker, and Governor of Montserrat and Mr. Tucker, the Honorable Mr. Reuben Meade, Premier of Montserrat, His Lordship, the Honorable Mr. Mario Michel, Acting Chief Justice, His Lordship, the Honorable Brian Cottle, Justice Brian Cottle, Resident High Court Judge, the Honorable Mrs. Marjorie Simmet, Speaker of the Legislative Assembly, Dr. the Honorable Ingrid Buffon, Minister of Education, Health, Social Services and Youth Affairs, the Honorable Mr. Cranston C. Buffon, Parliamentary Secretary, the Office of the Premier, the Honorable Mr. Dwayne Hickson, Parliamentary Secretary with the Ministry of Agriculture, Land, Housing, Environment and Sports, the Honorable Mrs. LaDonna Sweeney, Deputy Governor of Montserrat, the Honorable Ms. Renee Morgan, Acting Attorney General of Montserrat, the Honorable Mr. Paul Lewis, Leader of the Opposition, Her Honor Mrs. Vashti Chatou, Chief Magistrate, Mrs. Kristen Taylor Hilton, Acting Director of Public Prosecutions, Mr. Gregory Girard, Court Administrator of the Eastern Caribbean Supreme Court, Mr. Colin Meade, Registrar, and Mrs. Fanella Francis, Deputy Registrar of the High Court of Justice, Ms. Shivani Gerald, Vice President, Montserrat Bar Association, members of the Bar, Mr. Andrew Lewis, Acting Commissioner of Police, and other police officers present here today, staff of the Eastern Caribbean Supreme Court Headquarters, the High Court of Justice, and the Magistrates Court in Montserrat, members of the media, ladies and gentlemen, good afternoon. It is an honor to extend a warm welcome to you all. Thank you for accepting our invitation to attend this launch and media briefing for another milestone event implementing the ECSC E-Litigation portal for the High Court Criminal Division and the Magistracy in the Emerald Isle of Montserrat. Since its inception, the ECSC E-Litigation portal has revolutionized how the court provides access to justice. With this launching ceremony, we are taking another step in improving access to justice across all the court's member states and territories. We are also delighted to have the media present with us today. The court views the media as a vital partner in helping us to share critical information with our stakeholders. We do not doubt that you will help us spread the word about the many benefits the portal will bring to the operation of the Magistrates Court and the High Court in the territory. We have a cadre of speakers here today to share some brief remarks, and our first speaker is a barrister at law and managing director of the full-service law firm of Gerald Global Law. She is the vice president of the Montserrat Bar Association. In addition to her legal expertise, Ms. Gerald is a notary public and a certified mediator. She also serves on several boards, contributing valuable legal insight and strategic guidance to organizations across various sectors. Beyond her professional achievements, Ms. Gerald is deeply engaged in community service, where she is also a member of various charitable organizations, to include the Montserrat Foundation actively supporting initiatives that promote access to justice and social development. Please make her welcome to bring brief remarks on behalf of the Bar Association.
Thank you, Mr. Brissett. Good afternoon, everyone. Good afternoon, esteemed colleagues, members of the judiciary, and distinguished guests. Permit me to recognize Her Excellency the Governor, Honorable Chief Justice, and Honorable Justice Cottle. I am Siobhan Gerald, Vice President of the Montserrat Bar Association. It is an honor to stand before you today as we mark the launch of this groundbreaking implementation of the ECSC E-Litigation portal for the criminal module for both the High Court Criminal Division and the Magistracy. It's a development that I truly believe represents a new era for the legal profession. The practice of law has always been both an art and a science, rooted in principles of justice, equity, and fairness. However, like any enduring institution, it must evolve to reflect the needs of modern society. This online portal is not just a tool, it's a beacon of progress, efficiency, and accessibility, designed to simplify the often complex processes we navigate every day. In the past, filing of criminal matters would have often felt like an odyssey, with physical paperwork piling up and precious hours slipping through our fingers. Now, with the click of a button, filings will be quicker, errors reduced, and the time-consuming administrative burdens alleviated. Tempus fugit, as the Romans said, time flies. But with this innovation, we are reclaiming precious moments to focus on what truly matters, the pursuit of justice. Thank you. As we embrace this new technology, we also strengthen the very fabric of our profession. This portal embodies the principles of access to justice and accountability, ensuring that the court system is both responsive and resilient in the face of change. Allow me a brief moment of levity to lighten our legal hearts. I overheard someone joke recently that lawyers resist change because they argue both sides of it. Well, today I think we can all agree that this is a positive change worth celebrating. In closing, this portal is not just a technological upgrade, it's a testament to our profession's adaptability and commitment to excellence. Together, we are proving that the law, while rooted in tradition, is not bound by it. Thank you, and congratulations to everyone who made this vision a reality. Thank you.
Thank you, Ms. Gerald, for those kind words. I will now pause to welcome the arrival of the Premier, Mr. Ruben T. Meade. Thanks for coming, sir. Our next speaker comes from maybe the side of the bar where we are launching the portal for. And today, we will invite Mrs. Kristen Taylor Hilton, Acting Director of Public Prosecution, to bring some brief remarks on the Office of the Director of Public Prosecution. Please make her welcome.
Change can be, and quite often is, uncomfortable, but it is one of the very few certainties in life. Things will change. A very real example is this. The substantive director of public prosecutions was meant to be delivering today's remarks, but duties called him elsewhere. That change in the DPP's schedule has left me, in his stead, inwardly quaking at the thought of addressing the Chief Justice's baby, the E-Litigation portal, in front of the Chief Justice himself. Though I would prefer to greet each of our esteemed guests individually, I remind myself of time constraints. Consequently, Your Excellency, with your gracious permission, let me stand on the existing protocol as ably laid out by Mr. Dwayne Brissett. A pleasant good afternoon to all. I do extend sincere apologies from the Director, Mr. Ori Sullivan, that he was not available for today's proceedings, where we have assembled to celebrate the relaunch of the Eastern Caribbean Supreme Court's E-Litigation portal system, which brings with it, you guessed it, much change. The Eastern Caribbean Supreme Court has, over the last decade or so, recognized the need to further incorporate information technology into the pursuit of justice. Rightly so, I might add. The need for such initiatives became even more evident during the COVID-19 crisis. I'm wondering whether the powers that be had a vision of such crisis, as, if I'm not mistaken, the initial portal was launched back in St. Lucia, the territory of the Virgin Islands, and Anguilla in 2017, and then in the remaining states in 2018, albeit for civil and Court of Appeal matters. I wish to applaud the court for its foresight and its further responses to the ongoing need to modernize the judicial system in which we operate, so that the pursuit of justice may never, ever grind to a halt. Today, we commemorate the relaunching of this portal system, which is now more expansive than before. This change will incorporate electronic filing of documents into the criminal arena at the magistrates and high court levels in the criminal division. It will mean far less paperwork and far less paper wastage, which I'm sure our Premier will applaud, because arguably that will free up more money in our budgets for other necessities. The downside is that the portal means more hours sat behind a desk staring at a computer screen. Now, it is perhaps customary at the launch of anything to focus only on the good, the selling points, if you will. Nobody ever really wants to talk about the bad or the ugly. Nobody except criminal attorneys. Fortunately for you, I was inducted into the halls of criminal attorneyship over a decade ago, and finding the holes, the drawbacks, or the pitfalls in cases has sort of become second nature to me. So obviously, you will not be surprised that today I am going to be shining some light on some of the drawbacks of the e-litigation system. How brave I am. I am almost certain I heard someone in the audience gasp at the mention that this system might have any flaws at all, especially in the presence of the esteemed Chief Justice. But don't you worry. I'm going to get to the good parts just a little bit later. So breathe, everyone. First, a few drawbacks through the lens of a prosecutor. The first and very obvious drawback is that this system will cause some growing pains. Many of us are heavily reliant on administrative staff for things such as filing skeleton arguments, submissions, and indictments. Once I have prepared my court documents, I take pleasure on hitting the send button in Outlook, knowing that Ms. Claudina Ryan, our paralegal, will take care of the rest, at least until I get to the courtroom. After being spoiled in this way, it is definitely going to take me a minute or two to get used to filing my own documents, notwithstanding that I can do so from the comfort of my office chair. Though we are deep in the technological age, I am sure that there are some old school attorneys who much prefer pen and paper over computers and iPads. Some can send a WhatsApp message or answer a FaceTime call. But I am sure many will be rattled by having to navigate a new system. Remember what I said about change being uncomfortable? Though the portal is not difficult, at least not in my opinion, there are numerous tabs to navigate. Need to add instructing counsel? Do this. Need to file supporting documentation? Do that. Need to seal a document? Follow these steps. Like anything though, I suppose, the more you do it, the easier it will become. And I want to take a moment to thank the Eastern Caribbean Supreme Court, not only for rolling out this platform, but for sending very able court staff to deliver on-the-ground training for court staff and attorneys. I mention that this system is also meant to be utilized by unrepresented litigants. Perhaps in other territories, this is not really a consideration, as there are provisions for legal aid, and non-represented litigants are perhaps unusual. However, on these shores, defendants continue to have to represent themselves in criminal proceedings at all levels. And I openly wonder if, despite the portal having been designed to be easy to use, whether having to navigate the e-litigation portal will be difficult for many of our unrepresented defendants. What may come easy to the lawyers may not become so easy to the layman. I am aware that the service bureaus have been set up for some of our sister islands, and perhaps the same response will be implemented here. Another possible drawback is that only lawyers have access to the e-litigation portal. On first glance, you might wonder, what's the problem? For us in Montserrat, and I'm sure in many of the other 9 member states and territories, police officers here are entrusted with the prosecution of minor matters. In Montserrat, police prosecutors appear in traffic court, more often than not only for the sake of holding papers, but to embark on the entire trial process. The launching of this portal will make it difficult and perhaps a little messy when police prosecutors are expected to appear on the record but have no access to the filings of the portal. Police officers do not form part of the Office of the Director of Public Prosecutions, and I can foresee instances when the Honorable Magistrate has convened court to adjudicate on a traffic matter and has the displeasure of nobody appearing, or worse, a prosecutor before her who, by no fault of his or her own, is absolutely clueless. I'm not quite sure what the solution is to this problem, but I figured I would flag it anyway so that the powers that be may give it a little consideration. The final drawback, which I will comment on, is that the portal requires internet in order to access it. During our training, there were a couple of instances when the internet dropped and navigating the portal became impossible. When you live in a small country that has been facing electrical issues for far too long, those issues trickling over to the provision of internet and sometimes even data services, the inability to file a document in time because there was a power or internet outage scares me. I'm not so certain that His Lordship and his brothers and sisters would accept as an excuse. Sorry, my lord, I couldn't file my documents in time because Monlec was messing about, and Digicel and Lime decided to join in. In fairness, though, some thought has been given to this drawback because the portal does include a pack and go feature allowing attorneys to download the entire case to a device. But again, you have to be able to access the portal in the very first place, and the only way is through the internet. See, not as bad as you thought, right? Now that that is out of the way, if the moderator shall permit me, I do want to touch on some of the great initiatives. I want to touch on how awesome this initiative really is, especially after those kinks that I have just mentioned have been ironed out, and I have great faith in the Eastern Caribbean Supreme Court that they will be. The first major benefit I can see of this portal's implementation is that it will vastly cut down on the heavy bundles which we have to date been logging to court. Your Lordship, my back thanks you. No, I'm not as young as I used to be, and my body isn't doing the things I would want her to do. So I quite like the idea of having 5 cases worth of work accessible on one of many devices. No longer will I get to court and forget an important document that His Lordship is requiring of me. Nor will I have to frantically search through large bundles trying to find a medical form or a search warrant. No longer will administrative staff spend hours and hours searching drawers and cabinets for a missing case file. Information will be uploaded and stored on servers somewhere in the cloud, accessible right at our fingertips. This leads me to benefit number 2. The portal was designed with organization in mind. In my experience, lawyers, especially criminal lawyers, can be messy and downright disorganized, at least so far as paperwork is concerned. Sorry, friends. But the implementation of the system will help us all come correct. It helps that attorneys can have access to all cases, but also narrow in on his or her own caseload by the mere click of a button, from all cases to my active cases. Further, all of the parties in a given matter who have represented their interest on the system will have access to all of the documentation uploaded that touches and concerns a case without administrative staff having to make several copies of the very same document and then keeping track of who has been served, when, and how, particularly when several defendants jointly appear in a matter. Now, thanks to this portal system, Matthew, Mark, Luke, and John will all be able to see every document filed in the court by the Crown, except, of course, in those exceptional cases where a document has been sealed or has been uploaded ex parte. Another brilliant function, I might add, the ability to seal a document on the portal. In the interest of time, I shall provide only one last advantage, though I'm sure there are many others, and that is the availability of electricity and internet services aside, the portal allows for remote working. Our court system is vast, comprising of 9 different member states and territories sprinkled throughout the Caribbean region, spanning from Donga Bottom in Grenada to Upper Top in the British Virgin Islands. An attorney who travels through the islands or even further afield can still meet court deadlines by electronic filing. I can sit in Montserrat at the opening of festival and file an indictment for a matter in St. Vincent and the Grenadines. Or I can read supporting documentation whilst watching the sunset at Fort Young in Dominica. Further, I am not limited to the working hours of court staff, typically 8 to 4, but for some, 8:30 to 3:45. If I file a document at 9 p.m., it will be considered by the system as having been filed the following morning at 8 a.m. So the system allows the convenience of filing documents without the limitation of time. Well, limitations outside of strict court rules and orders, of course. No longer will administrative staff have to stand in line and wait at the court registry, though, to be fair, this is not too much of a problem in an island with less than 5,000 inhabitants. Notwithstanding, administrative and support staff will now spend less time in line and more time, we hope, at their desks. Overall, in my humble opinion, the relaunch and the expansion of the e-litigation portal to include the criminal field at the magistrates and high court level is a remarkable feat for the Eastern Caribbean Supreme Court. It brings me great joy and pride to know that despite the growing pains, which I'm sure will pass quite quickly, all things considering, the implementation of this portal puts the Eastern Caribbean Supreme Court in line and perhaps in some respects, even surpassing other states and territories in the provision of efficient judicial services. Montserrat is the last of the member states and territories to implement the criminal module. And dare I say, His Lordship saved the best state for last. As I take my seat, please join me in applauding the initiatives of His Lordship his brothers and his sisters, the court staff, and the entire Eastern Caribbean Supreme Court on the relaunching of the electronic litigation portal. Thank you.
Thank you, Honorable Acting DPP. I think we can give her another round of applause. Our next speaker is Her Honor, Ms. Vashti Chateau, the Chief Magistrate of Montserrat, a position she has held since 2018. I will now invite her to give brief remarks on behalf of the Magistracy. Please make her welcome.
Thank you very much, Mr. Speaker. Good afternoon, everyone. Now, the established protocol is adopted, but permit me to make special mention of Her Excellency Governor Sarah Tucker and Mr. Tucker, the Honorable Premier Reuben T. Meade, His Lordship, the Honorable Justice Mario Mitchell, and His Lordship, the Honorable Justice Brian Cuttle. Special mention, however, must be made of our recently retired Chief Justice, Dame Janice Pereira, who now sits as a member of His Majesty's Privy Council, and whose drive and determination saw the implementation of the e-litigation portal in civil and criminal matters throughout the states and territories of the OECS. For this, we thank her. As it relates to e-litigation, Montserrat is no stranger to this method of filing cases, both in the High Court and the Magistrates' Court. We began using this procedure in 2022 with the implementation of the civil module. Now, in 2024, we have come full circle. We are here today to launch the criminal module for both courts. By way of a little background, all, and I emphasize all criminal matters have their genesis in the Magistrates' Court. To put things into context, from 2019 to 2023, we had approximately 2,000 matters filed in the Magistrates' Court, 75% of these being criminal matters. Bearing in mind, during this period of time, we were on lockdown due to COVID. The paperwork, as you can appreciate, is enormous, as is the cost, and the possibility of errors occurring, and documents being lost or damaged due to natural disasters. And we experience this every year when we have hurricane season. With the digitizing of the criminal module in place, the possibility of all these will be reduced. Filing will be easier, it will be safer, and storage space for documents will be minimized. Presently, hard copies of complaints are filed at a magistrate's court through the Office of the Commissioner of Police. This will continue until his office is equipped to file those documents directly on the portal. We hope to see this being realized in the near future. What happens after that? On receiving these complaints, the Service Bureau at the court will then place these documents on the portal. The defendant will then be served. When served, the defendant will give that document to his attorney, who will be able to access all other documents on the portal using the authorization code. Persons will ask, what of defendants who do not have an attorney and wish to represent themselves? Will they have access to the portal to retrieve documents filed? Unfortunately, as you have just heard, they will not. Only court staff and attorneys can access data on the portal. All the defendants can access on the portal is the next hearing date by inserting their case number. Hard copies, however, of all documents filed on the portal will be served on the unrepresented defendant to allow them to conduct their trial. Not having access to the portal, what if the defendant needs to file a document? They simply go to the Service Bureau at the court's office, present the document, and it will be placed on the portal for them. A question that you are probably thinking about asking, so I'll answer. Can members of the public access information on a case? The answer is yes, they can, if they have the case number. But this access is limited to the hearing dates, nothing more. In like manner, if a defendant changes his attorney, his former attorney cannot now access any further information on this case. What are some of the benefits? Well, we heard some of them, but let me add. There will be a great reduction in the use of paper to begin with. In October of this year, CATAC, the Caribbean Regional Technical Assistance Center, conducted workshops on Montserrat in the area of climate and gender budgeting. The implementation of this portal dovetails neatly with the objectives of CATAC. Further, attorneys can at any time and on any day access documents filed, and in like manner, file their documents. They do not need to come to the court's office. Time, therefore, is saved. Attorneys will not now have to walk with bundles of documents to court. They can't be heard to say, I left my file in the office, or I was not served and need an adjournment. In the courtroom, they will have access to Wi-Fi, thanks to Mr. West and his team at DITES, making the portal accessible. I can hear persons asking, what of power outages? That's also taken care of, though in a limited way. Thanks to Mr. Riley, the property manager, the generators are kept running. And old matters filed prior to the existence of the E-Litigation portal can now be migrated onto the portal. Attorneys have, as you have heard, the Pack and Go feature. They simply download their case onto a thumb drive and walk with it, allowing them to conduct their cases offline while in court if necessary. We all know Murphy's Law. If anything can go wrong, it will. But we are well positioned to deal with them. Mr. Gerard and his team have in the past made themselves available to assist us and will continue to do so. The point, ladies and gentlemen, is the E-Litigation portal will have its teething pains, but it should not be feared. It's as easy as going onto your favorite app or seeking the personal assistance of the Advice Bureau. Before I close, I have a few trivia questions for you, which you will probably want to use on games night at your homes. First one, and you have 5 seconds to answer. When did the internet start? All right, 5 seconds have gone. That's a quick 5 seconds. 1983. This is when computers could have talked to each other. They had computers around before. In what year, next question, in what year could John Public, that's us, access a Google search? No takers? In 1998. Now, this one, to take shame out of our face, as they say, in what year did we access, or could we access, YouTube? I see the governor Googling that one. 2005. All of these platforms are relatively recent, you would agree. But it seems as if they were here forever. And we wonder, how did we ever get along without them? Last trivia question for you. I promise you, it is the last. What system is being implemented in 2024 that helps the planet and facilitates the efficient and effective and transparent handling of criminal cases in Montserrat? Of course, thank you very much. The E-Litigation criminal module. I'm sorry I don't have a gift for everyone. Ladies and gentlemen, in the not too distant future, we will wonder, how did we ever function without this module and without the E-Litigation portal? It will become second nature to us, as all these other platforms are. Thank you very much.
Chief Magistrate, I want to express my appreciation for your valuable remarks. I'm pleased to introduce Ms. Renee Morgan, a Jamaican who obtained her Bachelor's of Laws degree from the University of the West Indies, Cayville campus in 2009, and then obtaining her legal education certificate from the Norman Manley Law School in Kingston, Jamaica. She was called to the Jamaican bar in 2011 and later obtained a master's in tax law from the University of Melbourne, Australia in 2015. For the past 7 years, Ms. Morgan has served the people of Montserrat as Senior Crown Counsel and later Principal Crown Counsel, fulfilling a wide variety of roles as a passionate advocate, a careful negotiator, and a detail-oriented in-house counsel. Presently, Ms. Morgan is Acting Attorney General, while the substantive post holder, Mrs. Sherry Jemmott Rodney, is away on official duties. Let us all welcome her to bring brief remarks on the Attorney General's chambers.
Thank you. Good afternoon. I would like to adopt the protocol previously established by Mr. Brissett. However, I will formally welcome Her Excellency, the Governor, Mrs. Sarah Tucker, and Mr. Howard Tucker, our Honorable Premier, Reuben T. Meade, Honorable Chief Justice, His Lordship, Justice Mario Mitchell, the Honorable Speaker of the Legislative Assembly, the Honorable Parliamentary Secretary with the Ministry of Agriculture, Lands, Housing, Environment and Sports, the Honorable Deputy Governor, Mrs. Lindorna Sweeney, the Honorable Acting Financial Secretary, Ms. Alverna Weeks, His Lordship, our Resident Judge, the Honorable Brian Cottle, Her Honor, our Chief Magistrate, Ms. Vashti Chator, the Honorable Director of Public Prosecutions, Acting, and others who are present. I welcome you this afternoon. This is the launch of our criminal module for the E-Litigation portal for the court. And just have some short remarks today. I mean, I don't know, maybe the non-lawyers are not familiar with this, but I'm going to bring you along in this, that once upon a time, the English common law recognized a man called a reasonable man. He's a man who apparently lives on the Clapham omnibus in London. And this man now became the standard of all things legal, whether statements were defamatory, we consulted the reasonable man in our judgments and we put him in there. Now, that man on the Clapham omnibus has migrated. In Australia, he's now the man on the Burke Street tram. In Hong Kong, he's the man on the Shaw Kai Wan tram. And might I also suggest that this reasonable man has migrated to Montserrat. And in Montserrat, he's all of us. He is the man or woman at Cars Bay, the man or woman at Salem Square, the beach walk at Isles Bay, the sand miner in Corkhill. And these, ladies and gentlemen, are the people that those appointed to office in Montserrat in the administration of justice are here to serve. Litigation is often, though not always, conducted by somber-suited, black-robed men and women with 5 years' worth of special training and certification. Nevertheless, those specially trained are here at the behest of ordinary, reasonable people and for the purpose of the pursuit of justice. And important to our proceedings today is the thought that when these ordinary people I've mentioned, that man or woman in Cars Bay, Salem or Lawyers Mountain, the farmer in Drummond's, what these people think about law, when they think about law, when they visualize it, when they think about lawyers and courthouses and the work that is done there, they think primarily about criminal cases where lawyers have to defend persons accused of various crimes and the Crown's lawyers have the duty to prosecute fairly. They think about circumstances where persons have been victims of crimes and have to attend and give evidence. They think about where sons and daughters, brothers, sisters, husbands, wives, boyfriends, girlfriends, perhaps have been arrested, charged, have had search warrants on them, and potentially face time in prison or fines. So when we think about what the reasonable person thinks, the ordinary person thinks, we have to understand that the criminal justice system is the cornerstone of what our reasonable people understand about the law. and the launch of an e-litigation portal to cover criminal proceedings in the magistrates' courts, which sees the majority of legal cases on Montserrat, and the High Court is salutary. It will strengthen the public's understanding of justice when documents are now being filed instantly, served instantly, and stored in a format that's accessible in any location where someone has an account and a code. It will strengthen the public's confidence in the justice system, where documents are retrievable and less susceptible to loss through human error or natural disasters such as hurricanes or volcanic eruptions, which have both been known in Montserrat's history to cause severe depletion and destruction of court records. I also anticipate that it will significantly speed up the process of first instance hearings as well as appeals within the region. It would mean that persons who are convicted who are awaiting appeal may have their documents collated at relative speed, may transfer their matters to new counsel if necessary, and if it is merited that the conviction be set aside, this could be done before significant time is served. It should mean that the time of peculiar anxiety faced by all involved in the court process who are not of the somber-suited black robe variety, that is the victims, the accused persons, the jurors, their families, their schools and workplaces will be reduced. It should mean that we can look to a day when our reasonable people believe, and even more than believe, are certain that justice has been done and done quickly by those who are appointed to carry out the public administration of justice in criminal proceedings. Montserrat is the 9th and final member state to launch the criminal module of the e-litigation portal. Your outlook on this fact may well depend on whether you're in the habit of seeing the glass half full or half empty. The pessimists among us may feel merely satisfied that the time has come, having enjoyed civil proceedings on the e-litigation portal for some time now, and been one of the first jurisdictions to adopt that, for us to add what many people perceive as the cornerstone of the justice system to the e-litigation portal. For the optimist, however, we may reflect that in everything there is a first and a last, and that in any event there's a time when the first shall be last and the last first. Being the last, we have the privilege of cementing the foundation for e-litigation in the Eastern Caribbean Supreme Court and a marker of the milestone of having rolled out the implementation across all the jurisdictions. We should also have the privilege of learning from whatever teething pains have transpired elsewhere. Being the last, we should also be encouraged to be first in some things, and this is where I want to briefly exhort us today. It's a good beginning, and it's a day of great congratulation and honor for collective achievements, but not a day to rest on our laurels. It's a good beginning, but not the end of the e-litigation possibilities. May there be a day when, and I hope Montserrat will be the first, litigants in person, even incarcerated persons, will be able to view their online files and documents and be educated about the status of their matters through the e-litigation portal. May there be a day when there are special online resources for jurors while they deliberate on matters so that they can easily reference the documents that have been published to them. I guess, again, as I said, during deliberations with each other. Perhaps in becoming familiar with their documents in the digital world where many people already function in other capacities will allow persons to find the system of justice being less mysterious and anxiety-producing in future. Montserrat is already ranked highly in the region for clearing cases with relative speed. May there be a day when criminal cases are dealt with even more swiftly, reducing the emotional stress and anxiety on those persons and time spent away from the families, businesses, and projects, and general ordinary everyday life that the administration of justice, in fact, operates to preserve and protect. May the e-litigation portal move from strength to strength in its later iterations and be even better suited to serve these ends as we press on together in the pursuit of justice. Thank you.
Thank you, Honorable Attorney General. We will press on. Our feature address today comes from the Acting Chief Justice, but before His Lordship comes, I would like to tell you a little about him. His Lordship, the Honorable Justice Mario Michel, is a graduate of the Faculty of Law, the University of the West Indies, Caville campus, and the Woodin Law School. His Lordship was called to the bar in St. Lucia in October 1984. And he may tell you, but I will tell you as well, that this year His Lordship is celebrating 40 years at the bar. And we would have launched the E-Litigation portal in Antigua on his anniversary date. So that's a very commendable time. Some persons haven't even lived for 40 years, but His Lordship is practicing for 40 years. And entered into private practice, initially with a law firm, then from January 1986 on his own. In 1990, he established the law firm of Michel & Company, which he headed until May 1997, when he discontinued his legal practice to serve in government as a parliamentary representative and minister of government. In his 13 years in private practice between 1984 and 1997, His Lordship was very active in civil society, becoming the founding president of the St. Lucia National Youth Council in 1985, president of the St. Lucia Guild of Graduates in 1991, and president of the St. Lucia Bar Association in 1996. His Lordship returned to private practice as an attorney at law in January 2007, but was called to judicial service in February 2009, serving as an acting High Court judge of the Eastern Caribbean Supreme Court from the 1st February to the 31st of August 2009. On the 1st of September 2009, he was appointed as a High Court judge and was elevated to the Court of Appeal in September 2012. On the 5th of May 2024, His Lordship was appointed as Acting Chief Justice of the Eastern Caribbean Supreme Court. Please make His Lordship welcome to bring the feature address today.
Thank you, Mr. Brissett, Chairman of Proceedings. Her Excellency, the Governor, Ms. Sarah Tucker, and Mr. Howard Tucker. I'm not sure the last name. Probably put it at the end there. It's probably good. Thank you very much. Premier of Montserrat, Honorable Reuben Meade. Speaker of the Legislative Assembly, Mrs. Marjorie Smith. Parliamentary Secretary in the Ministry of Agriculture, Lands, Housing, Environment and Sports, Honorable Dwayne Hickson. Deputy Governor, Mrs. Lindora Sweeney. Acting Attorney General, Honorable Renee Morgan. Acting Financial Secretary, Honorable Kenya Lee. Opposition Parliamentarian, Honorable Nyota Mulcair, I hope I got that pronunciation right. Acting Director of Public Prosecutions, Mrs. Kristen Taylor Hilton, whom I will come to in a short while. Her Honor, Chief Magistrate, Magistrate Vashi Chateau. Vice President of the Montserrat Bar Association, Mrs. Gerald. Other members of the Bar of Montserrat. Staff of the headquarters of the Eastern Caribbean Supreme Court in St. Lucia, and staff of the High Court and Magistrates Court in Montserrat. Members of the media, invited guests, ladies and gentlemen. I was deceived into believing that there were 4 speakers before me who would deliver brief remarks and then I would deliver the feature address. It appears, though, that mine will merely be the fifth of the 5 feature addresses, with the preceding 4 feature speakers having already said all of what I had intended to say, particularly so the acting DPP. It is also instructive that the Acting Attorney General spend some time speaking about how bad it is to be last, which is my situation at this time. I hope, though, that the information that I will convey, not already conveyed, would be informative. Allow me first, Mr. Chairman, to thank everyone who's here for attending the formal launching of the criminal module of the Eastern Caribbean Supreme Court's electronic litigation portal, or the E-Litigation portal, as it is usually referred to. This launch today marks the culmination of the 3rd and final phase of the implementation of the E-Litigation portal in Montserrat, so that as of now, all new criminal cases in Montserrat, both in the High Court and in the Magistrates Court, and all new Magistrate Court cases which had not previously been onboarded on the portal, like juvenile cases and ticket trafficking cases, will be filed and managed on the E-Litigation portal. The actual go-live date, as it is referred to in the jargon, for the filing of these new cases is on Wednesday, but for certain logistical reasons, I believe associated with my travel to Trinidad on Thursday, the launch is taking place today. The implementation of the E-Litigation portal in Montserrat commenced on 2nd March 2020, when all new High Court civil cases and all new Court of Appeal cases in Montserrat had to be filed on the E-Litigation portal. Then from 14th June 2023, all new civil and family proceedings in the Magistrates Court had to be filed on the portal. And now, with the onboarding of all criminal cases, whether in the High Court or in the Magistrates Court, and all juvenile and traffic cases in the Magistrate Court, ushers in the complete digitization of the filing and servicing processes for all types of cases across all levels of the court system in Montserrat. Of course, Mr. Chairman, this is a significant milestone in our pursuit of a more efficient and accessible justice system in Montserrat and generally in the member states and territories of the Eastern Caribbean Supreme Court, and in fact manifests the court's commitment to modernizing our legal framework and embracing the digital age. With the completion of the rollout of the criminal module of the litigation portal in Montserrat, symbolized by this formal launch today, the Eastern Caribbean Supreme Court has now completed the rollout of the criminal module in all of the 9 member states and territories of the Eastern Caribbean Supreme Court. The onboarding of all Magistrates Court cases has not, however, been completed in all member states because of a particular legislative provision in Antigua and Barbuda which allowed for the onboarding of family division cases in the Magistrates Court, but not other Magistrate Court cases. I was informed this morning, though, that the relevant legislation has now been amended in Antigua and Barbuda, so it remains only for me as the Acting Chief Justice to do the finishing touches to enable all Magistrates Court cases in Antigua and Barbuda to be filed and served on the portal. This, I can say, with reasonable certainty, may I not, Court Administrator Mr. Gerard, um, should happen before the end of this year so that we can make a formal declaration of the full implementation of all phases of the e-litigation portal. This will, of course, Mr. Chairman, be a major milestone in our ongoing efforts, not only to modernize our judiciary and court system as a whole, but also to enhance accessibility to justice at all levels and within all areas of the judicial system. In order to fully appreciate what is taking place today and to put it into perspective, I believe that it is necessary to give a synopsis of the electronic litigation portal first introduced in the Eastern Caribbean Supreme Court some 6 years ago. The ELP was introduced in the Eastern Caribbean Supreme Court for the purpose of providing an electronic platform which would circumvent significant challenges associated with the traditional methods of filing and serving court documents. The portal was first rolled out in the British Virgin Islands in November 2018, encompassing at the time only civil cases in the High Court and cases before the Appeal Court. In the nearly 6 years since it was first introduced, in the Eastern Caribbean, the e-litigation portal has successfully transformed what was a time-consuming and resource-intensive process of filing and serving court documents into one which is now efficient, cost-effective, transparent, and reliable. There was a phased introduction of the various components of the e-litigation portal in different states and territories. The first phase of the introduction of the ELP in Montserrat, as I indicated earlier, was in March 2020, when the new High Court cases and Court of Appeal cases had to be filed on the portal. The next phase was in June 2023, when civil and family proceedings in the Magistrates Court had to be filed on the portal, and today's launch, as previously indicated, marks the implementation of the final phase. Gone are the days when every document to be filed in court proceedings in the High Court and the Magistrates Court had to be printed, and at least 3 copies had to be physically filed at the High Court or Magistrate Court offices between 8 a.m. and 4 p.m. from Monday to Friday. With the introduction of the e-litigation portal, court documents may be filed anytime, anywhere, and on any device. So that, for instance, you can now file a statement of claim in a High Court case or a defense in a Magistrates Court case in Montserrat at 6 in the morning or 6 in the evening, at a bar in Barbados or a beach in Bermuda, on your laptop or on your cell phone. Yes, anytime, anywhere, any device. The challenges associated with the process of personal service of court documents have also been obviated in most instances. Once the originating document, such as a claim form or notice of appeal, is personally served by the party instituting the court proceedings, along with an authorization code, the other party or parties to the proceedings have virtually immediate and unrestricted access to the portal. Thereafter, all documents filed on the portal are deemed to have been served on all parties to the case immediately upon being filed, thus eliminating the need for physical service of documents on litigants and lawyers wherever they may be located, whether in or out of the country. The use of the e-litigation portal, therefore, eliminates in whole or in part the tremendous amounts of paper previously used in the filing and conduct of cases, and significantly reduces the cost and frustration to litigants on both sides of a dispute, which might previously have been considered to be an inevitable and unavoidable feature of the court process. The fact that it is no longer necessary to physically go to the court office in the country where court proceedings have been or are being instituted in order to serve the court documents is, of course, beneficial to everyone involved in the process of litigation. But it is particularly beneficial to claimants or appellants who may be residing outside of the country where the proceedings are taking place or who may have retained counsel from outside. Furthermore, the portal has enhanced transparency in the judicial process because the parties have real-time access to all documents filed in their case, as well as to any notices or orders that may be issued by the court. Making the process of the filing of court documents electronic has also relieved court staff of much of the difficulty which typically accompanies the management and organization of physical files. Management of high volumes of paper created serious problems with storage space for court documents, which was exacerbated by our already limited infrastructural resources. The manual handling of documents left room for errors and delays in the court office, misfiled documents, missing pages, and the physical wear and tear of paper. All of these created serious problems. Paper is also known to attract dust and mold, which have proven to be hazardous to court personnel and chaotic to court offices, with court offices across the Eastern Caribbean being evacuated or vacated by court staff on several occasions because of problems with or complaints about dust and mold. The need for judicial officers to transport documents to and from the court added another layer of complexity, sometimes hindering the timely resolution of cases and sometimes just proving to be extremely inconvenient. This was particularly so with documents filed in the Court of Appeal. At least 6 copies of each document had to be filed in every appeal case, and the 3 judges hearing a matter filed in the Court of Appeal had to carry all of these documents from the Eastern Caribbean Supreme Court's headquarters in St. Lucia to the country where the matter was to be heard. For these trips every Saturday, traveling to and from the country where the appeal court is sitting for the week, the court had to pay thousands of dollars in overweight to the airlines on which we traveled, and police officers had to be deployed to carry the boxes from aircraft to vehicle, from vehicle to hotel, and from hotel to court when the matter was to be heard. So unseemly did this appear to be at times, especially in territories like the British Virgin Islands, where there were sometimes several boxes for each case. Police officers were known to complain about the apparent indignity of police officers in their formal attire, making 2, 3, or more trips carrying boxes for the judge to whom they were assigned. These were the norms which all of us, whether on the bench or at the bar, associated with the practice of law in the Eastern Caribbean, had become accustomed to prior to the introduction of the E-Litigation portal. Of course, in the digital age, the courts could no longer linger in the outdated modes of doing business, and we simply had to fall in line or be left behind. The Eastern Caribbean Supreme Court needed an efficient and convenient process for litigants and legal practitioners to interact with the court system. The E-Litigation portal, which was introduced in 2018, was the vehicle which we drove from the practices of the past to the procedures of the present. Since its introduction, the ELP has provided the residents of the states and territories served by the Eastern Caribbean Supreme Court with greater and easier access to justice, making the judicial system more contemporary and more efficient. Court staff have also benefited from a system of handling and managing files which is easier and more efficient. They no longer need to contend with reams of paper in files, folders, and boxes, which inconveniently took up valuable storage space and made location of documents cumbersome and burdensome. Court staff are now more efficient in their work because the portal allows for documents to be easily accessible, searchable, and retrievable. This had been so in the civil section of the High Court office in Montserrat since March 2020, and in the civil section of the Magistrates Court since June 2023. And this will now be so in the criminal section of the High Court and Magistrates Court offices from Wednesday. The E-Litigation portal has also made our court more disaster resilient, a benefit that resonated well with Dominica. Memories of the devastating impact of Hurricane Maria in 2017 have not yet been erased from the minds of Dominicans. As some may recall, the civil court registry in Dominica was completely destroyed. The damage was so significant that, to this day, the building housing the registry has not been recommissioned. All court files in Dominica were lost and had to be reconstructed with the assistance of the lawyers, so that lawyers involved in a case had to allow court personnel to use their notes to facilitate the reconstruction of court files. The electronic filing and management of cases through the E-Litigation portal will ensure that such a national disaster arising from a natural disaster will never repeat itself. We also saw how well we were able to navigate a worldwide pandemic because of the implementation of the initial phases of the E-Litigation portal prior to the full onset of the COVID-19 virus and the resulting lockdowns. These significant advancements, which we have introduced and continue to introduce into our court system, clearly evidence the Eastern Caribbean Supreme Court's resolve to leverage technology to improve efficiency, accessibility, and transparency of our judicial processes, and to expand the reach and access of our court system. The focus of the Eastern Caribbean Supreme Court can now be shifted toward the complete transition of all matters from the Judicial Enforcement Management System, or GEMS as it is called, which was the platform used by the Eastern Caribbean Supreme Court since 2001 in the management of all civil cases, to the E-Litigation portal, and from paper-based filing of court documents to electronic filing, which is a giant step towards a more modern, efficient, and accessible court system which meets the contemporary needs of our society while preserving and maintaining the integrity of our judiciary and our court system as a whole. It should be noted that GEMS was the platform used by our court system since 2001 in the management of civil cases, and was in fact our first use of digital technology in the Eastern Caribbean Supreme Court. On that note, I want to take this opportunity to strongly urge all the lawyers in Montserrat to migrate all of their previously filed cases to the E-Litigation portal. It is critical that we move forward with a unified system of case management for the greater efficiency of our court system in general and our judiciary in particular, and having all matters on the portal will assist us in achieving this. The court has provided guidelines for counsel to migrate their matters. These guidelines can be found on the court's website in a document titled the E-Litigation Portal Guidelines. And lawyers should make use of these guidelines in migrating their cases to the E-Litigation Portal with some urgency. It will be very unfortunate, to put it mildly, for the Eastern Caribbean Supreme Court to invest millions of dollars and many man-hours in the upgrade of the technology for use in the court system and for the training of staff to use the technology, only for some lawyers to frustrate its full utilization by refusing or hesitating to come on board the fast-moving vehicle of modern court technology. It should be noted, Mr. Chairman, that the completion of the rollout of all phases of the litigation portal does not mean the end of our efforts to modernize the court system in the Eastern Caribbean. Even as we have been progressing with the implementation of the e-litigation portal, we have also commenced certain other digitization projects that have taken the Eastern Caribbean Supreme Court into the realm of artificial intelligence. We have commenced the use of AI technology in the Eastern Caribbean Supreme Court through the use of a speech-to-text transcription system in the courtrooms where civil cases are being heard. This technology is already in use in Grenada, Dominica, St. Kitts and Nevis, and St. Vincent and the Grenadines, and will soon be introduced in Montserrat and the other 4 member states and territories of the Eastern Caribbean Supreme Court. And I want to serve a warning now on the court administrator to ensure that of the 5 remaining territories, Montserrat is not the last. This cutting-edge technology is anticipated to produce court transcripts with 95% accuracy in real time. So yes, transcripts will be made available to litigants and their lawyers in days, not weeks or months, or even years in some cases where documents may have been misplaced. The use of this AI technology in our courts will therefore guarantee greater accuracy in the production of these critical court documents and also eliminate the very significant, sometimes costly, and often embarrassing delays which hamper the pace of hearings and the disposition of cases in the court system, particularly appeals for which transcripts are absolutely necessary in almost all cases. The Eastern Caribbean Supreme Court has also commenced the deployment of a second speech-to-text system utilizing Microsoft Azure AI technology. This system will address the backlog of Liberty audio recordings in some of our courts, yielding text transcripts of up to 80% accuracy. Needless to say, the Eastern Caribbean Supreme Court will benefit greatly from these technological advancements, ensuring more timely and accurate production of transcripts and records of proceedings. Mr. Chairman, the proof of the pudding, they say, is in the eating. But rest assured that several slices of this pudding have been eaten and enjoyed by court users throughout the member states and territories of the Eastern Caribbean Supreme Court, including right here in Montserrat. At this juncture, I wish to extend the appreciation of the Eastern Caribbean Supreme Court for all of the effort and hard work that has been put into the modernization of our court processes in the last 6 years, both by the staff at the court's headquarters in St. Lucia and the staff of the various court offices in all of the member states and territories, including Montserrat. Your dedication and commitment have been instrumental and have not gone unnoticed. I extend also special thanks to our former Chief Justice, Dame Janice Pereira, now properly called the Right Honorable Dame Janice Pereira, for her leadership in the implementation and expansion of the e-filing system in the Eastern Caribbean Supreme Court. In closing, I wish to emphasize that these technological advancements, from civil cases only to criminal cases also, and from high court matters alone to magistrates court matters as well, represent more than mere technological upgrades. They are steps, giant steps, along the road towards a more effective and inclusive justice system, and evince the court's commitment to harnessing the power of technology to enhance the delivery of justice and ensure that every resident of the member states and territories of the Eastern Caribbean Supreme Court has access to a fair and efficient legal process. I implore all of our court users, litigants, lawyers, judicial officers, and court staff to embrace these advancements in our court processes with optimism and enthusiasm as we continue to evolve as a court that prioritizes efficiency and responsiveness as it does justice and equity. I thank you.
Just want to thank the Honorable Chief Justice for bringing Part A of our media launch to a close. We will move into Part B, where members of the media here will get an opportunity to ask questions to our technical team, and also members of the audience who would like to ask questions will get an opportunity to do so as well. So at this juncture, I want to thank the Honorable Chief Justice, the Honorable Acting Attorney General, Acting DPP, our Chief Magistrate, and our Vice President of our Bar Association for participating in Part B, Part A of our media briefing. And at this point, I just ask you to take your seat. So Chief Justice will will replace Mr. Gerard, and other members can sit wherever you please. Thank you very much. And can give them a round of applause, please. I will now invite Mr. Gregory Gerard, our court administrator, and Mr. Anderson Henry, our system administrator, two members of our technical team, to join us at the head table.
Good afternoon, all. As Mr. Brissett mentioned, we are now moving into the section of the program where members of the media can ask questions if they have any questions about the implementation of the portal, if there are any burning issues that come to mind. And of course, we'll allow members of the audience as well to ask questions if they have any. It seems our presentations were is on premiere. There's no cost to access it, but when documents are filed, whether by self-represented persons or attorneys on behalf of their clients, they have to pay the necessary filing fees. But there's no cost, like there isn't an annual fee to have a login to the portal or anything like that, no. Sure. Thank you for that. The issue of the unrepresented litigants has been something that has occupied our minds as we've been implementing the portal. What I want to add, but I'll address that more directly in a minute. But what I wanted to add is we've been doing the portal implementation for the last 6 years. And at some point, we had to say, look, let's roll out, even if we know we don't have everything perfectly working, because we might be here another 2 or 3 years waiting for these features to be fully enabled. So now that we have the portal rolled out, what we are going to work on the aspects relating to the unrepresented litigants, because it has arisen several times. I even think there have been a few cases where persons who are self-represented have raised a challenge at not being able to have access to it. So it's something we are quite aware of. We have a couple of ideas in mind on how we're going to resolve it, but we need to think it through and work it out and allow, the developers to at least configure the system to work properly. But yes, that is something that's on the table. The challenge I am thinking about is for persons who are on remand, and how would they access equipment, scanners, pay the fees that are necessary, and so on. Again, even if we make it available to self-represented litigants, that might be a phase 2, because it may not be possible immediately. But we are aware of those issues, and we certainly want to resolve them.
So I just want to add that although the practitioner should serve the litigant in person the physical documents, a litigant in person, a company perhaps, can agree to be served electronically. So rather than print those files and serve them physically, they can agree and let the court know that they wish to be served electronically. So you maybe email them those file documents, so the printing of the documents. So we can get around that in some instances. But a litigant in person who does not have access to technology must in some way be aware and access those files, and the physical form is the way that they will be served. But a litigant in person who's savvy enough and opts to be served electronically can be served that way. All right. So when it comes to security, as you know, the hackers always somehow find a way around the security measures. I'm just reading a new one where a large telecom in the US was hacked by a state, what they consider to be a state-sponsored agents from another region. But getting back to the portal, I digressed a little. So the portal is developed by a company who's ISO certified, security certified. So the protocols for development and the methodologies encompass security at the core. And that's Crimson Logic out of Singapore. The communication from the source, the computer where the information is generated, to the servers where the data is stored, it's secured. So it's SSL, secure socket layer encrypted. And also the data at rest, the database is encrypted. So even having access to the database would not give one access to the files on the database. What one typically sees when it comes to hacking is to first cleverly get one of the users of the system to compromise the system. And that's by executing something on the server or retrieving credentials. The portal does not allow even those administrators the ability to go delete files or do anything of that nature. If you access your documents, you're not running the document on the server, and you download it to the local machine. So a hacker would really have to get the credentials of a specific user, and in that case, what you get is access to the user's information. And what you can do is not delete or corrupt the information that that user has uploaded, but maybe you can file a document and misrepresent what the person would actually want to file, but you can't compromise the system by uploading a corrupt file, because there is a process of validating the type of file and the contents of the file. So these are some of the security features. So every user has a username and password. It should be complex, as is recommended. And we're looking at implementing other forms of authentication, because that seems to be the way, especially where a hacker has, say, a keylogger on a user's machine. So they actually they compromise your machine, get your username and password. They can't, as far as we are aware, mess up our information, but they can get access to the user's information. So having multi-factor authentication would protect against that. So there are different security measures from that technical perspective. There are other aspects of the portal as it pertains to the security of the information, and two of them were mentioned: being able to file a document as a sealed document. So a party on the other side who should not have access to the document at the point in time cannot read the contents of the document. An ex parte document, they are not aware of the document, etc. Thanks.
Thank you. Another question? Oh, I have a note to address some of the points the acting DPP said when the questions are finished. But yes, I will speak to that in a minute. Yes, Your Excellency. Pardon me? How are we measuring the efficiency? You have
Well, in terms of the filing time.
Well, the efficiency comes from the cost savings, as was mentioned. I mean, you no longer have to print 5 copies and 7 copies of, let's say, a record of appeal and things like that. You can work from your office to file documents, so you don't have to get a staff member. As absolute numbers at this time, I don't have any. Yeah. Pardon me? Yeah, certainly.
All right. So when it comes to the efficiencies brought about by the portal, there are some efficiencies that one would not see as off the top. But if you look at a practitioner who's perhaps living in Isles Bay, who now has to file a document in braids, there's the commute time if they were to file that physical document, and that would be, I don't know, 30 minutes, 20 minutes, and the fuel cost, etc. So if you look at efficiencies from a cost perspective, just for the practitioner who's now able to submit the documents from their office or from their home in Ulverston, then that's something that they can start to track. How much fuel am I saving by not having to drive up and down to file those documents? There are the multiple copies that one would typically have to compile to file the physical, at least 3, and say 5 or 7 in the appeal, in the case of an appeal matter. And now you only have to have that source document, the 1 copy. And at least if you're taking that physically to the court, you need that 1 copy. If you're doing it from your office, there are tools that allow you to create and sign PDF documents and file those, so there's no need for printing or for scanning. So not just the time, the cost. And with the court staff, you have the issue of space, the cost of space and storage, and the cost in terms of time for staff retrieving documents. That's a big one, where someone comes to find, okay, I have a probate matter that was done 2 years ago. We now have to go into, someone has to go into a vault and spend the time finding that document or that record. So there are lots of efficiencies that the courts will eventually realize that may be difficult to capture from our perspective, because we're not on the ground and we don't know those exact costs. But the practitioners have, we have had practitioners give us an indication of how much it has saved them in terms of now doing business with the court.
Yeah, but I would add that I think it will require us to make certain assumptions, because clearly we will not be able to give a precise figure for everything because it's so difficult, different islands, different scenarios. But I think it's certainly an exercise that's worth looking at to try to identify, well, under these assumptions, these would be the cost savings or the efficiencies that the portal would bring to users and the system.
Especially
Thank you.
litigant is in the UK, for instance, who has interest here.
Yeah, I mean, my colleague was just reminding me, I mean, we have this ability now where a litigant in the UK or any country around the world can make an arrangement to file their document without ever leaving the UK, because they would just need to email a copy to the registry, the service bureau, make an arrangement for the filing fee to be paid, and there are a few options for that, and the document will be filed. When it's filed, it will be emailed to them, the filed copy will be emailed to them with whatever other information is required, say an authorization code, and they can do with it at that point what they wish to do. So there are a number of things, as I say, if we are to make some assumptions, we can try to come up with some quantitative stuff. Any other questions? Okay. Oh, sure. Okay, I'll take the first stab at that, and Anderson will add if I miss anything. Essentially, the e-litigation portal through our software providers, Crimson Logic, is hosted on Amazon Web Services. Amazon Web Services has data centers globally, and they do data replication from one place to another. So a disaster which might affect a data center, let's say in Peru, I'm just using a country, might put that data center out of commission, but another data center which might be in Sydney, Australia, would not be impacted by the same disaster, and it would be operational again. So that's how we've sort of built up that sort of resilience, as the Chief Justice mentioned, to keep going even in times of disaster, even if a disaster affects one of AWS's hosting sites. Yeah.
Sorry. Just from a law firm perspective, law firms can do their own backups. So they can do the pack and go and save that to their network access storage, their own local IT infrastructure. So all of their cases are stored electronically on their own devices. So they don't rely on direct access to the portal as a backup means. So that's encouraged as well. So you download, just do a pack and go, and it's practically zips every case file, all of the documents that you have access to in that case file, and you can save that to your local hard drive, thumb drive, just so you have a copy of your case files and you're not relying on the portal. So that's one way of practitioners taking into their own control of their own backups. All right, but so far, and I think some of the practitioners here can attest to that, we have had more than 99.9% uptime in terms of availability of the portal, and that's one of the service level agreements we have with our providers.
Okay, thank you. No, any other questions? Okay, thanks. I just wanted to touch on a couple of points which were made by the acting DPP. In terms of, I think one of the concerns which was identified as a possible, I think, growing pain or initial teething problem was that only lawyers have access to the e-litigation portal. Within a law firm, it is not only lawyers, it is also the law firm secretaries have access. I'm not too sure. Some offices don't always add persons who are non-lawyers. I don't know how DPP's office in Montserrat is organized, but certainly law firm secretaries can have access to the portal as well as the lawyers. Which brings me to the other point where I think you mentioned you have to file your own documents. That's not quite accurate. Upon initiation of a case, if that was being commenced by the DPP and the case was created, a law firm secretary can actually create the case and it is saved as a draft on the system. Yes, there is a limitation that only a lawyer in the firm can do that initial initiation to create a case. So yes, a legally trained, a lawyer in the DPP's office will have to say, create, like go into the draft and create the case. And that's where, from there, submit, yeah. Yeah, the secretary can create the draft and the lawyer needs to submit the case to create the case and get your case number. I think from there, the law firm secretary, any document that has to be filed can be filed by a law firm secretary. So in the scenario I think you mentioned, you said that you would email a copy of a document to someone in your office and probably in the paper world, they would bring it to the court. Now you can still do that. You can create your document, email it to the law firm secretary, and he or she can add that document to the case file without having to go to the court to submit it. So that's just a slight adjustment to the comment that you made. I mean, the point about service bureau and self-represented, I mean, it's a taken point, and as I say, it's something that we are looking at. But with that and the whole police prosecutors issue, we had to start the portal at some point and to begin to roll it out. We've been rolling out since March this year for the criminal module, and it's December, and we finally finished all 9 member states. If we had to wait for those aspects of the system to be developed, we would not be at that stage yet. But I would like to hasten to add that for police prosecutors, and I mentioned that to a few of the police prosecutors, I think when they were at the training, we've identified a solution which we are going to implement, which is going to give police prosecutors access to their case files on the portal. So even if they are not legally trained, they're not lawyers, but they are prosecutors, they do have audience before the court, whether it's a magistrate's court or whichever. So they will have the ability to access the case, to file documents, and to do some of those things. So I think in the new year, we will probably be working on that, because this issue came up from the time we started. I think it was BVI in the first instance, and then followed by Grenada, who was second. So we recognize that it is an issue, but we wanted to move forward with the rollout at this stage. The other point you mentioned, which is a valid point, the internet dropping and electricity, well, that's a real issue. But I think fortunately, at least over the 6 years or so since the portal has been implemented, we have not seen any major problems like that. And I think the one that comes to mind is a problem that happened near Anguilla, where I think the undersea line, the fiber, whatever it was ripped out, and they were without internet for about 2 days. In the island, the entire island was without internet. They survived that, and I mean, I don't think anything was found to be out of time, and that's the thing. If there's something that happens, what I would say, I mean, as lawyers, you would probably think of ways to indicate to the court what happened. My power went. There'll be a utility company that can certify that this happened. And as long as the court is satisfied that this is a genuine event, then of course the discretion is still with the court to make that determination. But I think there are steps that can be taken to demonstrate a genuine challenge that you may have faced with filing. Right now, every now and then, we do have problems leading up to 4 o'clock. Every time, 10 to 4, quarter to 4, lawyers call, I can't file this document, it's not able to be filed. We have a system in place, and we say, look, if you can send us a copy of the document. Unfortunately, I'm talking about an issue where the portal may have a problem, and they say they can't access it. We tell them, send us a copy of the document that you have, so they need internet. We will keep a record of that, and then we will put a note on the file the next day when it can be uploaded. You see, this was sent to us, this is the document, and it was sent to us before 4 o'clock. So it would not be deemed to be out of time. So there are things that we try to do on the manual side when you have these little problems. So as they arise, and if they continue to arise, we'll have to think of what the solutions are, because the intention is not for people to be locked out or unable to file whether internet is down or electricity is down. So I don't know if that addresses and sort of eases some of those growing pains a little bit, and not all perfect now, but I think over time, you know, those growing pains will hopefully all go away. Thank you.
Just to touch a little further on the growing pains or the disadvantages that the acting Deputy Director of Public Prosecution spoke of. So the issue of filing Greg touched on, but there was the issue of the older attorneys, and this one is dear to me because I literally get goosebumps when older attorneys tell me, Anderson, this is easy, and it's not. It's really a case of becoming familiar, and we've put on the portal, on the court's website, video guidelines on how to do common things that practitioners will do. So how to file this, that's on the portal. How to create a case, there's a video. So if one is not familiar with how to do that on the portal, you could just have the video and go through that video, and step by step, you see the steps, you just go and do what you need to do, and that should be a good guide. But we also encourage older practitioners to enlist the help of a younger person, perhaps in their office, to help with the technology aspects. I can't type on a keyboard just because my fingers. So perhaps like there's need to engage a younger person to do that clerical aspect. Somebody who knows how to log in and submit, and you know that you've done what you're good at. You've done the legal aspects, you've drafted your documents with pen and paper if you like, you've dictated it. But you have that, and so just getting it to the court is what you enlist the help of a younger person, not necessarily employed, but maybe someone even from your household. Time. Okay. All right. And lastly, so the unrepresented litigants, they will continue to go to the court, but we are also looking at a means of giving unrepresented litigants access to the portal, just as we're looking at methods of getting the police on, and the incidents of police prosecutors not knowing when their matter will come up. Once they're on, they will get that notification. They will know now because the court will serve them with summons to appear or a hearing date. So what happens now will continue to happen, but it will just be enhanced once they get on the portal, that they will get those notifications via email to the police at their desk. All right, thank you.
Oh, Premier.
Mr. Brissett.
We have to now start looking at, we are in fact going electronic, even in meetings such as this. Let's go electronic.
Honorable, Just a quick thing. Honorable Premier, we have used QR codes to get the programs. Mr. Brissett will explain why we didn't use it this time. Okay, I seem to recall you came to the training a little bit late last Thursday. Um, but what we indicated to the DPP at the training was that when the cases are created, the DPP's office will be added as what we call an interested party in the case. So they will have, the whole case, all documents filed in the case, so they can see everything that is happening. Then if they wish to take over the case, then it would be simply a case of having the lawyer withdraw their representation. They would get the authorization code and they can now represent the virtual complainants. So there is provision for dealing with the private criminal matters. Welcome.
Thank you. Honorable Premier, the issue of printing programs, Mr. Gerard can tell you, I tell him we're not printing. However, when we look at our list of invitees who had accepted our offer, protocol dictates that we print a minimal amount. Normally, I would print them in St. Lucia and take them down, but I asked the registrar and the deputy registrar not to print more than 15 programs. We normally print 60, so we are now at the 5%. We are following, Grenada has a policy in place that no more than 5% must be printed across government, so we instituted that. We just had a lecture in St. Kitts, and we printed only 3 programs. One for the Chief Justice, one for the Governor General, and one for the Premier, for the Prime Minister. Everybody came, they go on the wall, and they did their barcoding. Because I have an issue with I have to walk around and picking up the programs that persons leave on the chair because we rent the venue, and I do not believe that we should leave it messy. I'll now invite the Deputy Registrar to move the vote of thanks, and after which I'm going to ask a few persons to remain to take some photographs so that we can memorialize this event. Ms. Fanella Francis.
Ladies and gentlemen and honored guests, good afternoon. I acknowledge the protocols that have already been adopted, observed, and I fully adopt them. Today has been a remarkable success, marking the culmination of a significant collaborative journey. This achievement would not have been possible without the vision, dedication, and hard work of many contributors. First, I extend my deepest gratitude to the Eastern Caribbean Supreme Court for their foresight in recognizing the need for an e-litigation portal and for driving this vision to its completion. Your leadership and commitment have been pivotal in this initiative. I must especially thank the Honorable Chief Justice for gracing us, sir, with your presence today. Your support underscores the importance of this milestone in the judiciary's modernization efforts. To the exceptional implementation team, both those present and those who worked behind the scenes, IT Manager, Mr. Mark Ernest, Chief Registrar, Mrs. Michelle John Thibbles, Court Administrator, Mr. Gregory Gerard, Systems Administrator, Mr. Anderson Henry, and Application Support Officer, Mrs. Cynthia Ramjiwan. Your hard work, expertise, and dedication have been invaluable. Let's have a well-deserved round of applause for this team. I would also like to acknowledge the local stakeholders whose participation enriched today's event. Acting Attorney General, Ms. Renee Morgan, Her Honor Chief Magistrate Vashti Chatur, and Acting Director of DPP, Mrs. Kristen Taylor Hilton, and of course, our Vice President of the Bar, Ms. Siobhan Gerald. Your insights and contributions to today's program have been vital to its success. To the members of the Legislative Assembly, heads of departments, attorneys at both the public and private bars, the Police Commissioner's Office, and members of the media, your presence here today signifies your commitment to progress and the innovation in our justice system. Behind the scenes, many individuals played crucial roles in making today a memorable experience. My sincere thanks go to the decorator, caterer, photographer, protocol team, all of whom have done an outstanding job. Special recognition goes to the Attorney General's Office and the Magistrates Court, whose efforts have ensured that our honored guests were warmly welcomed and comfortably accommodated. Thank you. Every project requires dedicated individuals who go above and beyond, those who make the calls, send the emails, and ensure that no detail is overlooked. For the ECSC, that has been Mr. Dwaymian Brissett, who has been talking to you for most of today. Thank you, Dwaymian. For us at the registry, that person has been Mrs. Francilis White, who ably supported us and who was ably supported by our capable and committed staff. Thank you, Mrs. White. Thank you, registry staff. Your diligence and determination have not gone unnoticed. Finally, I must acknowledge Mr. Colin Mead, who consistently goes the extra mile, burning the candle at both ends. To all of you, mentioned and not mentioned, thank you for your contributions, your support, and your unwavering commitment to advancing our justice system. Together, we have achieved something truly transformative, and we look forward to the continued success of this initiative. Thank you.
Thank you, Deputy Registrar. And I'm going to move swiftly. I want to thank you, Mrs. Fanella Francis, for moving the vote of thanks today, and for everyone who worked tirelessly behind the scene to make today's success a reality. We say a big thank you to you all, and I want to thank everyone for taking time out of their busy schedule to join us for this milestone event. I wish you all a safe journey home or back to your offices. With the permission of the Honorable Chief Justice, I wish to bring the formal proceedings of this evening's event to a close. Thank you all. I will ask the Chief Magistrate.